Good evening, and hello to you. Welcome to Paradise. Excuse me. I probably should have brought out some cough drops. I know I'm competing with Josh, and I don't mean to compete with Josh, but actually, it looks like I'm competing with Wally. Well, I don't mean to compete with them. I intend to watch their stuff later. They don't tend to have advertisements on theirs. I also don't have advertisements on mine, so I hope nobody feels like they have to rush out and watch my stuff because it'll be on later. And yes, Pennsylvania versus Mimms. Hello, Mary. Hello, Tom. And hello, Chris. Hello to you too, Kenzie. So, hi, Jared. This video came out. I did watch about 10 minutes or so of it. I got to the point where he was discussing a particular statute in the Oklahoma Revised Code. Did I just kill a mosquito on my head? Jesus, this is going to be bad. Don't watch. Alrighty. Hi, Ed, and hello, and I exist. You are here, and you do exist. So I got to a point where he was discussing a specific Oklahoma statute. I did spend the better part of my lunch when I am sitting there eating, reading not just that statute, but searching for case law on that statute. And I can't find anything on it, but we'll discuss that, I guess, when we get there. He is boring as hell. So just so you're aware, this guy is boring AF. We are going to do him on 2x speed. And can I review Magic Johnson versus Larry Bird? I could. I know those names sound familiar. I think they're sports ball guys. Hello, Ryan. And Freeman's also live. Wow. There's just, as Jackpot would say, there's a whole lot of wackadoodles live. So, but anyway, my stuff isn't monetized. So if you want to go watch somebody else's, go ahead and do it. And you could always watch this later if you get super bored. Yes, he does do a PowerPoint. And yes, you will need another drink. Don't let Coded find out, because that little shitbag will call you an alcoholic and tell you that you have fish tanks to hide the smell of urine, because he's that kind of little douche. But anyway, on to the star of tonight's show, Mark Adams, a.k.a. Discussing Laws. Is he a tennis player? I always thought he was like he's from Boston or something like that. So he's what is that, a Patriots thingy or something? I don't know. Isn't shit now I'm double second guessing. Are the Patriots from Boston, or I don't know. I don't fucking know. I don't fucking care. And I don't want to fuck Coded. And basketball. Well, I don't know. It's tennis or basketball. Are the Patriots basketball? I don't even fucking know. I don't know. I don't care. Why are we getting off on a tangent here? Let's do a little Pennsylvania versus Mimms.
I finally decided to do a video on Pennsylvania versus Mimms. It's a 1977 U.S. Supreme Court decision that basically applies Terry v. Ohio to traffic stops, specifically related to ordering a driver out of the vehicle. I'm doing this now because there's a video that I watched recently that made me think of this case again. We're going to show it at the end of my short presentation as a case study. But first, this is a discussion of legal theory. When you're pulled over by police, it's not the time to argue theory. You may be able to beat the rat, but you can't beat the ride. So play nice. The facts of the case were, first, police performed a traffic stop on a car in Pennsylvania with an expired plate. And second, the officer that did the stop had a practice of ordering all drivers out of their vehicles as a matter of course whenever they had been stopped for a traffic violation.
So just so that you're aware, yes, the officer did have a practice, but I don't think that's super relevant. What they're saying is that why the Supreme Court mentions that is because the officer didn't have any particularized suspicion. The dissent goes into the dissent argues in Pennsylvania versus Mimms that the court is expanding Terry versus Ohio because now you could just pull everybody out of a car willy-nilly. You don't have to have any particularized suspicion that crime is afoot or that they're armed or dangerous or anything like that. You just pull out for whatever reason. But the majority opinion refutes that, saying first you have to already have a particularized suspicion in order to conduct the traffic stop in the first place. So now that you have you've satisfied Terry v. Ohio as far as the stop. Getting them out of the car is just, it's perfunctory. You can have any reason or no reason. And in fact, it's a scholar. What is it? It's Maryland. It's Maryland Supreme Court, Mimms. Maryland versus Wilson. So the case that Discussing Laws likes to ignore is Maryland versus Wilson. And I'm going to do this since I have two screens. I am going to share two screens. I'm going to put this over here. Ooh, look at that, how it brightens me up. So in Maryland versus Wilson, they didn't talk anything about the police officer having a practice of getting the driver out. You can what they held in Maryland versus Wilson is, see, this is what the Supreme Court thinks that they held in Maryland versus Wilson. This is what in Maryland versus Wilson, the Supreme Court interprets Pennsylvania versus Mimms as this particular holding. In this case, i.e. Maryland versus Wilson, we consider the rule of Pennsylvania versus Mimms. Now, this is the rule of Pennsylvania versus Mimms, that a police officer may, as a matter of course, order a driver out of a lawfully stopped vehicle or car to exit his vehicle, and that extends to passengers as well. We hold that it does. So the rule is that a police officer can, as a matter of course, tell the driver to exit the vehicle. And pursuant to Maryland versus Wilson, he can also do the same thing to the passenger. So that's what it's all about. So now that we have that kind of basic understanding, we can go back to this douche canoe. That wasn't the holding of Pennsylvania versus Mimms. Let's find Pennsylvania versus Mimms, because he doesn't show anything. He just summarizes it for you so that he could lie to you. Pennsylvania versus Mimms. And we're going to show this tab instead. So they deal with pulling him out first, and then there remains a second question of the propriety of the search once the bulge in the jacket was observed. Right. So they pull him out. All they talk about before this was can we order the guy out of the vehicle? That's all they talk about. Now, once they've ordered the guy out of the vehicle, oh, you can't hear him? All right, oh, hold on a second. Shit. I'm going to go back to the beginning then. But anyway, let's just deal with this real quick, all right? So I don't have to go back to it. So they did the holding. All of this up here, all of this, the top stuff was whether or not they can order the guy out of the vehicle. Now, as the guy was exiting the vehicle, the officer who had ordered him out of the vehicle noticed the bulge. And don't we all notice the bulge? I mean, we all notice that bulge, right? So once they've noticed the bulge, the second question is the propriety of the search once the bulge in the jacket was observed. So they've already done a stop. That is, if we could, it was just on 2 times speed. Well, fuck, Michelle, are you leading me astray? Are you leading me astray, Michelle? I've been told reliably that you've been leading me astray. Shall not infringe on my bulge. Well, I mean, what if he's really hot, or she, depending on, I don't know how you roll, bro. But what if he or she is really hot? So yeah, so once they notice a bulge, because there's already a lawful Terry stop, and then bada boom, bada bing, you can do the Terry frisk, right? Easy peasy lemon squeezy. So let's go back and let's listen to it. Let's listen to it again. It's on 2x speed. We didn't get very far. We'll just watch it from the beginning. All right, roll tape.
I finally decided to do a video on Pennsylvania versus Mimms. It's a 1977 U.S. Supreme Court decision that basically applies Terry v. Ohio to traffic stops, specifically related to ordering a driver out of the vehicle. Doing this now because there's a video that I watched recently that made me think of this case again. I'm going to show it at the end of my short presentation as a case study. But first, this is a discussion of legal theory. When you're pulled over by police, it's not the time to argue theory. You may be able to beat the rat, but you can't beat the ride, so play nice. The facts of the case were, first, police performed a traffic stop on a car in Pennsylvania with an expired plate. And second, the officer that did the stop had a practice of ordering all drivers out of their vehicles as a matter of course whenever they had been stopped for a traffic violation. The court applied those facts under Terry v. Ohio to see if a police officer, after a valid traffic stop, could order a driver out of the vehicle without violating their Fourth Amendment rights. The court's holding related to search was that the additional intrusion can only be described as de minimis. The driver is being...
Well, that's that de minimis is the holding from Terry versus Ohio. Terry versus Ohio said, well, you know, once you've been seized, once the cop has reasonable articulable suspicion to seize you, it's a de minimis intrusion for him to pat you down, for him to gently caress your bulges or something. It's de minimis. It's just a pat down over your clothes. Now, if the cop starts going into pockets, if the cop starts making you pull things out, whip it out, you know what I'm saying? If the cop does that, then it's not de minimis, but just a quick pat down, boop, 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 over your clothes, easy peasy, lemon squeezy.
Asked to view very little more than is already exposed. And then as related to seizure, the court's holding was that the police have...
So yeah, being asked to expose to view very little more than is already being exposed. Yeah, that's because it's supposed to be over the clothes, right?
Already lawfully decided that the driver shall be briefly detained. The only question is whether he shall spend that period sitting in the driver's seat of his car or standing alongside it. When it is at most mere inconvenience cannot prevail when balanced against the legitimate concerns for the officer's safety. Under Terry v. Ohio, the Fourth Amendment analysis is always the reasonableness in all the circumstances of the particular governmental invasion of a citizen's personal security. Reasonableness depends on a balance between the public interest and the individual's right to personal security, free from arbitrary interference by law officers.
So, you know, PowerPoints are great and everything like that. But it would really be nice if you'd actually like put citations to where these things were. I understand that these are all in Terry v. Ohio, but he's pulling them out of order. And
so right away, Pennsylvania v. Mimms has a very specific...
So notice also he has like the Fourth Amendment analysis is always, and then he starts his quotation. And then he ends his quotation. And then he goes on to say reasonable depends on a balance, yada, yada. It's like, are these things... Oh, it's puppy playtime. Are these things actually direct quotes, or are they your understanding of it? It would be helpful to have the actual quote because Mark Adams very clearly cannot accurately summarize a case. He doesn't understand the holdings.
Specific fact pattern, and that the police officer, in this case, would order people out of the car as a matter of course. So if a police officer doesn't do that at the...
Hold on a second. Let's listen to that again.
V. Mimms has a very specific fact pattern, and that the police officer, in this case, would order people out of the car as a matter of course. So if a police officer...
So Mimms has a very specific fact pattern, but is that really the issue there? Does any subsequent case, not just necessarily even at the Supreme Court level, show me one federal case that summarizes Mimms saying that the officer has to have a pattern, a policy of ordering people out of the car. Show me one. He won't do that. And the reason why he won't do it is because it doesn't exist. That's why he won't do it.
Officer doesn't do that at the majority of their traffic stops initially, and as a matter of course, Pennsylvania versus Mimms isn't going to directly apply. Although
it absolutely will directly apply because Maryland versus Wilson says directly that an officer may, as a matter of course, order a driver of a lawfully stopped car to exit his vehicle. It doesn't condition it on whether or not he has a pattern and practice of doing that.
Case could be cited to argue that the proper analysis of whether a police officer can order a driver out of a vehicle against a different fact pattern is a Fourth Amendment reasonableness analysis under Terry v. Ohio.
But it couldn't be argued that because it's never been applied that way. I guess technically you could try to argue that, but it's not going to go anywhere.
Initially, and as a matter of course, Pennsylvania versus Mimms isn't going to directly apply. Although the case could be cited to argue that the proper analysis of whether a police officer can order a driver out of a vehicle against a different fact pattern is a Fourth Amendment reasonableness analysis under Terry v. Ohio.
But it's not. So the reason why he could do the seizure, the reason why he could pull them out of the vehicle is the Terry analysis. You already have to get through a Terry stop analysis to get them out of the vehicle in the first place. You've already stopped them. There's already been a Terry stop. That you have to have a reasonable articulable suspicion, reasonable suspicion supported by articulable facts that that crime is afoot, right? And that this guy might be the one doing it, right? You already have to have that. So why would you have to do a second Terry analysis? Why would you have to do a second one? There is no precedent for having to do 2 Terry stop analysis. What would the second one do? You already have said, yeah, the crime's probably afoot. I'm going to pull over this vehicle. I'm detaining the occupants of this vehicle. They're already detained. And now I want to order them out of the car. Oh, second Terry stop analysis. I already have determined that there's probably crime afoot. So they get to come out. They can pull you out for officer safety. They could pull you out for convenience. They could pull you out just because they thought you were being a dick and they want to make you sit outside in the cold. The officer may, as a matter of course, order the driver of a lawfully stopped vehicle to exit the vehicle. Done. That's as far as the court fucking cares. Done. You may hate it, but that's it. Problem solved. Can they do it? Yes, they can.
The justices found that the public interest under Terry v. Ohio was really as to officer safety. 2 different officer safety reasons were mentioned in the holding. First, according to one study, approximately 30% of police...
Two officer safety holdings were mentioned in the holding. Which holding? Terry versus Ohio or Pennsylvania versus Mimms? I think he's talking about Pennsylvania versus Mimms, but he's not citing to anything, so how the fuck do we know?
Shootings occurred when a police officer approached a suspect seated in an automobile.
Sounds like Mimms.
Second, the hazard of accidental injury from passing traffic to an officer standing on the driver's side of the vehicle may also be appreciable in some situations. I'm underlining it.
Oof, he's underlining it. Can they pull out the bulge? Well, it depends. How much are you paying the hookers? They would pull Michelle out just to check her out. That's what I hear. I hear she has some nice fun bags.
In some situations, because by using those words, the court is admitting that this hazard of passing traffic won't apply to every traffic stop.
The court doesn't fucking care because again, like I don't know how to make this any simpler. Regardless of any other factor, the officer may, as a matter of course, order you out of the vehicle. As a matter of course, doesn't have to do any analysis. As a matter of course, and the Supreme Court hasn't directly addressed ordering them to remain in the vehicle. I've read case law from the Court of Appeals level in Jesus Christ, what circuit was that? At least one circuit that I don't remember off the top of my head said that it just stands to reason if they could order you out of the vehicle, they could order you to remain in the vehicle. So there you go. They order people out and they were saying for officer safety. Well, I know, but like you're detained. Like, so imagine you didn't have a vehicle. Imagine you were detained just on this. Just you were walking down the street. You're walking down the road, and the officer says you're detained. Right? He has reasonable. Let's just assume, for the sake of this discussion, that he has reasonable articulable suspicion. Right? He could then tell you sit there on the curb. He could tell you to go stand next to that building. He could say go put your hands on the hood of that car. Right? He could do all those things. Yeah, it is like a game of Simon Says. It's a game of Simon Says with a guy who has a gun and who probably is authorized to use it. It's a very high stakes game of Simon Says. And he can handcuff you, yes, and he could possibly tase you, or depending on the circumstances, maybe even shoot you. He could use force to compel you to comply. And yes, very kinky. Can they order you and the passengers to play musical chairs? I mean, I don't know. That's getting a little bit far out there. I don't know. I don't want to speculate on that. I mean, if you pay me enough, sure. All right, let's go back to it. Ooh, pew pew, a hypothetical situation. Yes, they can. But they don't have to, because again, as a matter of course, oh, you're not watching any of this. God damn it. No one tells me. All right.
And then here, my poor graphics skill show the driver shooting at the officer as the officer approaches the vehicle's driver's side. Pew, pew. What the police
Pew pew sound effects. Woo!
officer should probably do is take cover behind his door and order the driver out of the vehicle from a distance. Most police don't do that because they're usually not ordering you out of your car because of safety.
All right. Salty Explorer says we have to start over from the beginning, guys. So everybody thanks Salty Explorer because we're going back to the beginning. I don't know when we lost audio.
Can they really argue safety issues of standing on the driver's side of the door if they choose to approach?
They don't have to argue. They don't have to argue safety issues because, as Maryland versus Wilson clearly lays out, and as Pennsylvania versus Mimms says, is that they can order you out of the car. All right, everybody is on the board that we can hear it now. Oh, we can't. Well, it's not playing right now. I'm waiting for you bastards to figure it out. I hate you all.
Approach the driver's side instead of the passenger side. An important thing that the justices don't seem to take into account is the safety of the driver from traffic too.
Well, so safety of So here's the problem. There is no perfect safe solution, right? But in that situation, the Supreme Court has just kind of made a blanket ruling. They don't really care. This isn't a balancing test. This isn't anything other than you've already been detained. The officer can order you out of the vehicle. The officer can order the passenger out of the vehicle. He doesn't have to do any more tests. He doesn't have to do any more showings. There's no way that you can suppress the evidence that he finds from ordering you out of the vehicle because it is not a violation of the Fourth Amendment. It's a petty indignity to be ordered out of the vehicle. Oh, she hasn't shown him to you? You don't know what you're missing out on, WTT. They're amazing.
There is an important footnote in Pennsylvania versus Mimms that says, we do not hold today that whenever an officer has an occasion to speak with the driver of a vehicle, he may also order the driver out of the car. We hold only that once a motor vehicle has been lawfully detained for a traffic violation, the police officers may order the driver to get out of the vehicle without violating the Fourth Amendment prescription of unreasonable searches and seizures. So the footnote isn't just saying we apply the reasonableness test and determine that these specific facts made it not a Fourth Amendment violation. Instead, it's saying as long as the vehicle was lawfully detained in the first place, so the police officer pulled him over for a valid traffic infraction, the police officer can automatically order the driver out of the car without violating the driver's Fourth Amendment rights.
It doesn't have to be a valid traffic infraction because we've actually seen, what is that, Hine v. North Carolina. So this is Hine versus, I'm going to say Hine. I don't know exactly if it is Hine, Heien versus North Carolina, a 2014 decision. In this particular case, the officer pulled over the driver because one of the brake lights was out. And the officer reasonably but mistakenly believed that you had to have two functional taillights to operate your vehicle in North Carolina. And so they find cocaine. And the defendant was like, holy shit, we need to suppress this evidence. You know what? I didn't have to have two functional taillights. I only needed one. That's what the statutes say. I only needed one. And the U.S. Supreme Court said an officer can make a reasonable mistake of fact or law, and it's still a valid arrest, or it's still a valid detention. It doesn't become unlawful at that point. It doesn't become an invalid detention. In fact, it is quite possible for you to be arrested on a mistake of law or a mistake of fact and still be able to be convicted of something that you actually committed or that they could prove beyond a reasonable doubt that you did, whether you did or you didn't. Speaking of which, yesterday, Friday was the big day. Friday was the big day. WTT, your boy, the state didn't file their brief. Their brief was due on the 27th. That was Friday. And the state didn't file their brief. Huh. Well, isn't that something? Isn't that something? $10.27, the state's brief was due. Well, it was originally due on 9/27. They filed a motion to extend the time. It was granted. They were given till 10/27/23 to file their brief, and I don't see it. I just opened this up today. I'll refresh it just in case. Just did a refresh, and what is that, like control? That's a brand new roof. That's not my cache. Interesting. Have a good night, WTT. Interesting. Sorry for the little detour there. What were we talking about?
In the case law, though, this footnote is currently being disregarded, as it should. If you look at all the citations to Pennsylvania versus Mimms, and there's close to 5,000 that are just mentioned in Lexis, there's a lot of them that say that the case is distinguishable because the police officer in our instance did not have a habit of, nor did he immediately order the driver out of the car, but rather violate a traffic infraction. The police officer can automatically order the driver out of the car without violating the driver's Fourth Amendment rights. In the case law, though, this footnote is currently being disregarded, as it should. If you look at all the citations to Pennsylvania versus Mimms, and there's close to 5,000 that are just mentioned in Lexis, there's a lot of them that say that the case is distinguishable because the police officer in our instance did not have a habit of, nor did he immediately order the driver out of the car, but rather ordered.
Why doesn't he show any of these cases then? Why doesn't he show any of these cases? And do the cases prevail? Like, making an argument is one thing. It's easy to make an argument. But why doesn't he show these cases? Why doesn't he show one case where that argument was made and was successful?
The driver out at a later point in the stop. The police officer doesn't implement a policy of always ordering drivers out of the vehicle, then Pennsylvania v. Mimms does not apply. Either another.
See, if he had something, if he actually had case law on it, he would show it. He doesn't.
A case must be used, or one must conduct a reasonableness analysis. The video we're going to look at next happens in Edmond, Oklahoma, with that city's police department. So here's the relevant law that I want you to be aware of while you're watching the video. In Oklahoma, unlike in most states, the police can arrest for traffic infractions that occur in their presence, but misdemeanor arrests can only be made before 10 p.m. Note that.
So this is where I got lost. Misdemeanor arrests can only be made before 10 p.m. That's where I got lost. I spent a long time searching for this. Well, not a long time searching for the statute. The statute was fairly easy to find. It's this statute right here. So I have questions. I did a lot of research on this afternoon, or around, well, while I was eating my lunch. I did a lot of research on this, and I could only find one 10th Circuit case. Let's go to case law, select courts. I did 10th Circuit Court of Appeals. I did, share this tab instead. 10th Circuit Court of Appeals, Eastern District of Oklahoma, Northern District, Western District. And then I did Oklahoma, just the whole shebang. He alleges that he is. I have no idea what that means. And yeah, shock Pikachu face. All right, and then we did, how do they do this again? They do 22 OS 189. I think that'll find it. And that's it. That's the only case that I have found. Now, this case right here is a case where there is, in fact, a warrant. There's an outstanding warrant. The warrant arose, yada, yada. So the arrest was made pursuant to a warrant. And 189 is so plaintiff has asserted that the bench warrant for the arrest of Deborah Boyd, which lies at the root of this dispute, was invalid at the time of the alleged search of the O'Rourke residence under provisions of Oklahoma state law related to nighttime arrests for misdemeanor offenses. 22 OS 189. But I also found, and I'm not going to show you all of that because it took a lot of digging and hunting and pecking to find these cases. But there were a lot of cases where people were arrested after 10 p.m. Most of the cases involving most of the cases involved the use of alcohol, misdemeanor. There are misdemeanor DUIs in Oklahoma. There's all sorts of things that people got arrested for that I found after 10 p.m. So going back to the statute, my instinct is, my hunch is that this has to do with just warrants. This is an arrest under warrants. I covered that already in a previous stream, and I don't think anything's changed, but just for shits and grins, I will double check. Wallace. Boom. Strike says. Yeah, nothing's changed since my stream. He has till 11:3. 11:3 to clarify his intent. You did miss it. So, where were we? Yes. So my hunch is that this applies to warrants. Now, there is also an exception. Specifically, this talks about if there's a warrant. An arrest on a warrant may be made at any time if the defendant is in a public place or on a public roadway. Now, I'm going to. It would be strange. Yeah, I agree with you, Juan. I agree with you. But the problem is I can't actually show you a case. I don't have LexisNexis or Westlaw, so I can't show you a case. But here's the rationale that I'm using. Number one, it would be illogical that someone could make an arrest on a warrant in a public place or on a public roadway after 10 p.m. But they couldn't make an arrest on any other misdemeanor without a warrant between 10 p.m. and 6 a.m. So that wouldn't make sense. But the other thing is that our intrepid adventurer, Delete Laws, has done nothing. He just makes the assertion, right? He doesn't show you where like the courts have interpreted this statute the same way that he interpreted it. And that's what's really important when you're briefing a case for a court of appeals or something like that, or even if you're doing law in motion, and if you do it right, the way you do a table of authorities is you start off with case law first. Case law is the first thing you cite. Then you go down to constitutions. Then you go to statutes. Then you go to any policies or regulations or anything like that. Then you go to treatises like the Rudder Group's civil practice before trial or whatever. You work your way down that list. But if you notice, the most important thing, the thing that carries the most weight is case law, because statutes are written like shit. Generally speaking, statutes are written very open-ended, and it takes a lot of cases to really work the edges of the statute into something that's clear, that has definitive edges. So I'm going to say that he had the burden, that discussing laws had the burden of showing that you cannot get arrested for a misdemeanor, made a warrantless arrest for a misdemeanor that was valid under this statute. 22-196, arrest without warrant by an officer. So if one of these applies, then he would have the burden of showing that it doesn't apply. Now, there's also another one. I'm going to go to, I think it was 11. And was it 16? This. There we go. 1134-101. 1134. Oops. 4. So a municipal police officer, i.e. a city police officer, shall at all times, have the power to make or order an arrest for any offense against the laws of the state or the ordinances of the municipality. The officer shall have such other powers, duties, and functions as may be prescribed by law or ordinance. So it wouldn't make any sense that only police officers can make an arrest at all times, right? It wouldn't make sense. I just have to assume that Mark Adams is reading it wrong. Again, I don't have case law. So if we're looking at the intent, at least according to O'Rourke, is to prevent nighttime arrests for misdemeanor offenses. And it would appear from the statute that my guess would be from the statute would be that it's really trying to prevent warrants from being served at someone's home between the hours of 10 p.m. and 6 a.m. So, fucking skeeters. Spraying myself down like a wild animal. There was a blessed like 2 or 3 week period where there were no mosquitoes out here, and it was amazing. And I have one of those ultraviolet light thingies that Dynatrap. It's literally like right above me under the pavilion, and the mosquitoes just absolutely ignore it. I think the onus is actually on discussing laws. He says it, but he doesn't show it.
The event in the video happens after 10 p.m. though. The resisting statute in Oklahoma applies when a person knowingly uses force to actively oppose an officer in the discharge of any duty of his or her office, and also the officer must have probable cause and authority to arrest.
So he adds in that the officer must have probable cause and authority to arrest, and I didn't see that in the resisting arrest. Let's see. Let's go to share those tab instead. Oklahoma. We're going to do uniform jury instructions. And boom. I don't like this one. I like. Why aren't you loading? All right, and then we're going to go to resisting, and it's resisting a executive officer. So these are the elements. These are the elements that you have to prove. No person may be convicted of resisting a peace officer or an executive officer unless the state has proved beyond a reasonable doubt each element of a crime. These elements are. So this is everything that the state would have to prove. That the person knowingly resisted. They resisted by the use of force or violence. Third, they resisted. Fourth is an executive officer or a peace officer, i.e. a cop, and he has to be in the performance of his or her official duties. Nowhere in there does it say that resisting arrest has to be with probable cause. The officer had to have probable cause. And then obstructing an officer, again, does not mention anything about probable cause. And nowhere in the definitions does it require the officer to have probable cause. So he's just plain making shit up now. So the reason why he threw that in there is because he wants to make that after 10 p.m. work. But it doesn't work because, again, I'm pretty sure that applies to warrants. There is another resource that I had looked at it, and then Frog brought it up again, and I did a little more investigation in on it just to show Frog that he was wrong, because that's what I like to do. I'm a terrible person. But I had already looked at it before Frog posted a snippet of it. But inside of the DHS, there is the Office of Inspector General. This is the Oklahoma DHS Office of Inspector General. And they have two sections. They have search warrants, arrests, and criminal process, and searches without warrants. So the one that we want to look at is search warrants, arrests, and criminal process. Now, when they talk about arrests, right? Right in here in section 3, unless specified in the warrant, yada yada yada. Right? This looks like it's just talking about the same things that were in that 22-189. But then they have another section, arrests without a warrant. And this section doesn't have anything about the time. So it's anecdotal evidence, just like all the people who got arrested after 10 o'clock. And no one, I mean, if this was a thing, you would think there would be something. There would be something that you'd be able to find in Google Scholar, right? What attracts mosquitoes is exhaled CO2, an old soda bottle, 2-liter type, a couple inches of water at the bottom, and a tablespoon of baking soda added every 20 minutes or so. Make a trap. All right, I might try that. Well, again, like I believe you, Juan. I totally believe you, and that's the way I would lean, because California has a very similar statute. California Penal Code 840, and all of these are derived from the common law. So they all have a similar basis in the law. There was a time when a lot of these states, before they developed their own robust body of stare decisis, they would all look at each other's and see what everybody else did. So you can see here, the arrest for a commission of felony may be made at any time of day or night. This tracks. An arrest for the commission of a misdemeanor or an infraction cannot be made between the hours of 10 o'clock p.m. of any day and 6 o'clock a.m. of the succeeding day, unless it is made with a warrant. It's made in a public place. Boom. Made in custody when a person's in custody pursuant to another lawful arrest, or made pursuant to a warrant which, for good cause shown, directs it may be served at any time of the day or the night. So you could see that again. I really think that is the correct thing. But it would be great, Juan, if your buddy criminal law attorney in Oklahoma could send you or send me or send to you to send to me the case, or like a section of the practice guide or whatever, the Crim Pro practice guide. It would be great if we could see something on that is kind of definitive. We have bats, and we also have put up what are those, like bat houses? We have bats that live in the barn, and then I put up bat houses, and yeah, we like bats. The bristle babies are doing just fine, thank you. And one does have connections, and he also has a luxurious mullet, the most luxurious of mullets. Thank you, Juan. I appreciate it. And what is up, cunts? Tampons? I don't know. You tell me. You tell me, Biff. You're the cunt in this equation. So what's up, you? Ha ha! He's got jokes, folks. Anyway, back to this.
And resist without breaking the law. Probable cause is a slippery slope because the officer is going to claim he didn't have the statute memorized, and that a reasonable officer could have thought that there was a violation of the law, even though clearly the statute doesn't support it. The obstruction statute in Oklahoma applies when a person knowingly delays an officer in the discharge of any duty of his or her office. We also have to weigh this against the Edmond Police Department's policies. Although the Oklahoma state law says police can arrest.
Well, so no, the Fourth Amendment doesn't give two shits about the police department policies, and police department policies don't trump state law. And I did not look up Edmonton Police Department policies.
Arrest for traffic infractions, as long as it's a misdemeanor and it happens before 10 p.m. The policy says traffic violations will not routinely result in an arrest, but violators may be arrested for refusing to sign citations as it presents a failure to appear risk. The police.
So he doesn't have that in quotes. Let's see if we can find it. Edmonton Police Department policies. Edmond, Oklahoma Police Department policies. So nowhere in arrests. Let's see if we can't find. What was he saying? He was saying traffic violations. Page 2. So, all right. Make this bigger again. Where was it? Page 2. All right. So this is permissive. Arrest without a warrant may be executed as specified in Oklahoma State Statute Title 22 OS 196 for misdemeanor offenses committed in their presence. Note: traffic violations will not routinely result in arrest, but as per Title 22 OS 11115.2, violators may be arrested for refusing to sign citations as it presents a failure to appear risk. So it doesn't say they won't. It just says that they won't routinely do it. It's not they're not required to do it as routine. It doesn't say they can't. It doesn't say they won't. Mark claims to have graduated from law school in like Minnesota or Michigan or one of those northern states. Well, I don't know. I don't know. I don't trust a word Colin says. Um, I think it's likely that Mark is working on this stuff with Chili, poor Chili, but I wouldn't read too much into it if the Tony Tones guy exists. Free speech, buddy. Legal counsel is a term of art that means an attorney. You're not entitled to non-attorney representation. All right, so let's go back to the old video.
Police in Edmond shouldn't be arresting people for traffic violations. If they do arrest someone for traffic violations,
Shouldn't be, or they shouldn't routinely do it. Let's listen to that again.
assign citations as it presents a failure to appear risk. The police in Edmond shouldn't be arresting people for traffic violations. If they
Well, I mean, you're drawing a lot from they won't routinely do it, right?
do arrest someone for a traffic violation, automatically it's going to be looked at as retaliation because they're
Why would it automatically be looked at as retaliation?
shouldn't be arresting people for traffic violations. If they do arrest someone for a traffic violation, automatically it's going to be looked at as retaliation because they're arresting someone but typically exercise the discretion not to. The person is
Well, I mean, he's talking about the class of one, and so they're going to have to show more than just this policy manual. It says they won't routinely do it, but there are other instances where they will, like drunk drivers. Those are traffic violations, right? It's a traffic violation that's a misdemeanor, but they don't routinely not arrest drunk drivers. They don't just hand them a fucking ticket and send them on their merry way, right? So I think the officer is still allowed to use his discretion. And I haven't seen the video yet. I know there is one, so I guess we're going to get to it. But I would be interested to see why the cops arrested this guy and what all they arrested him for. But I guess we'll get to it.
exercising their rights when arrested, then it's going to look even more like retaliation. This is the
Exercising your rights when doing it's going to look more like retaliation. See, this whole idea that exercising your First Amendment right is a panacea to allow you to do whatever the fuck you want in a traffic stop, it doesn't work that way. Like, once you have been detained, you are under the control of the police. You've been detained. Like, you have less rights at that point. Your right to your freedom to travel, right? You have a right to travel. All of a sudden, once you're detained, you have lost that fucking right. You have a right to bear arms, but as soon as you get detained, boy, they're fucking taking your gun off you, right? You have the right to do a lot of things, freedom of association, but they can say, no, I'm putting you in the back of the car. You'd be like, I want to call my mom. No. Oh, but freedom of speech. Well, fuck you. You have fewer rights. You are detained. You are detained. You are in custody at that point of a sort, a limited custody, but a custody nonetheless.
textbook definition of civil rights retaliation. An officer is going to lose any probable cause and qualified immunity.
Show it to me. Show it to me. Where just as a matter of course, if an officer makes an arrest for a traffic violation in Edmond, Oklahoma, show me the fucking case. I mean, this is all conjecture, all theory with no proof.
Regarding use of force, an officer should use de-escalation techniques and other alternatives to higher levels.
Should. He even highlights it. He underlines it. Should. An officer should. Well, I agree, an officer should. But what if the officer doesn't? Then what? Then what? Does that nullify everything? I mean, you know what? If an officer hurts you, maybe you have a Fourth Amendment claim for excessive force. Maybe you do. I don't know. It's going to depend on a lot of facts. But if he doesn't use de-escalation, that doesn't mean shit.
Of force, consistent with training whenever possible and appropriate, before resorting to
should, whenever possible and appropriate. 3 qualifiers. What does that tell you? Well, you know, I mean, if you can.
Force and to reduce the need for force. Although you'll notice that Edmond police wrote this using the word should, so an officer isn't required to use de-escalation techniques. It's in their discretion based on their feelings.
It's in their discretion, consistent with their training, whenever possible and appropriate.
Violations of internal policies forms the basis for disciplinary action,
which is not something that you can sue over.
A lot of times when an officer goes at you and wrongfully arrests you, there's just no fair fight in the legal system due to probable cause and qualified immunity. But if they violated a policy, make sure and make a complaint. Maybe you can get them written up. You can also use those policies to show retaliation.
You can't use policies necessarily to show retaliation. It's not assured. Maybe, but maybe not. Like just because this is in their policy manual, if every day, every Edmond police officer is out there making an arrest every time for a traffic violation that's a misdemeanor, every single. Well, here's a fucking question for you. Is a speeding ticket a misdemeanor in Oklahoma? Oh, you can't see what I'm looking at. Sorry. They are misdemeanors. Okay. What's going on over here? That is correct. It was. We've strayed far afield. He's too stupid to fake something like this. Well, shit. Put another case of beer in the fridge. I mean, pour it down your throat, bro. You could be apparently. Hold on a second. Let's go back to. We want to go back to. Title 22, Section 1115. Well, I think I already have Title 22 up, don't I? Uh-huh. So released on OR if valid license, satisfied with the identity, promise to appear, violation does not constitute a felony, negligent homicide, driving while under the influence, eluding or attempting to elude, operating without a driver's license, arrest based on outstanding warrant, or a traffic violation coupled with any offense stated in A through F. All right, so they should not arrest unless there is one of those. All right. Canada, my state, Bill. Louisiana. I trust the scissors guy. Nice. Could discussing all this possibly be more wrong? Attribute to Matthew Perry. Oof. Big oof. Okay. All right. And oh, that is very kind of them. Yeah, I find being an asshole to a cop who has the power to give you a ticket or a warning. Probably don't be an asshole and you'll get the warning.
All right, so here's the video.
On September 17th, 2022, an officer with the Edmond Police Department in Edmond, Oklahoma was on patrol when he saw a silver vehicle with a broken third brake light.
I wonder who's... Oh, here's the original video. What's the original video? From Audit the Audit. Fuck, this guy's a moron. Audit the Audit's a fucking moron. I've watched 2 of his videos in the past, and I did like Ramblin' While Ambulance on him back in the day. And he's a fucking idiot. So we've got a legal idiot reviewing another legal idiot's video. This will be great.
So right here is the first interesting thing. The narrator says broken taillight. As you notice here in a second, though, that's not what the police officers are saying.
The 39-year-old driver, Brandon Riles, turned into a parking lot, and the officer activated his emergency lights to conduct a stop of the vehicle. The interaction that followed was captured on the officer's body camera.
How you doing? Where's the pulling over your third brake?
Apparently, this is from real body cams. DUI. Count 1. Oh, fuck. DUI. Count 1. Drug paraphernalia, dangerous substance, i.e. marijuana. Ooh, dangerous. Driving with a canceled, suspended, or revoked license. Oh, shit. Let's go back. Oh, you fucking idiot. You fucking idiot. Oh, Jesus Christ. So you don't arrest. This is back to you release them on personal recognizance unless the violation is a felony. Okay. Negligent homicide. Okay. Driving while being in actual control of a motor vehicle while impaired or under the influence of alcohol or other intoxicating substance, yada, yada, yada. Or operating a motor vehicle with a suspended, revoked, or canceled license. Wah, wah. Oh, you fucking idiots. You fucking idiots. Oh, Jesus fucking Christ. All right, let's go back.
Brake lights up.
Right there, the police officer says it's out.
My third brake light? Yeah, the one of the... Yeah, no, it works pretty good. No, it doesn't.
So right here, whether the officer has done a detention or traffic stop in order to investigate whether an infraction has occurred, or if the police officer believes he has probable cause to arrest, the police officer is still required to look at exculpatory evidence provided. Here, Mr. Riles says, no, it works pretty good. That's when the officer should be conducting additional investigation. Instead, he says, no, it doesn't.
Well, what if, and you can tell me how dumb and wrong this is. What if the cop was like, "Oh shit, this guy appears to be driving drunk. I saw him weave. I saw him do something, right? I'm pretty sure he's drunk. I want to get him out of the vehicle. Maybe he's ran this guy, and this guy has a background." Let's see. I wonder if I could find any more. Is there any way to search? Is there any way to search court records? Search court records. Here we go. And that is 1983. We won't. Gimme. I don't care about that. All right. Go. Found me a case. Found me a lot of cases. I found me a lot of cases. Oh, Lord. What is TR? TR is speeding. So TR is traffic violations. What is a... That might not be it. What is a CF? What is a CF? A felony. Assault battery with a dangerous weapon. Another CF. What do we got here? What do we got? DUI. Another DUI. Carrying a concealed weapon. Kill it. Oh, fuck you. All right. So let's go back. So the officer pulls up. He says, I think this guy's drunk, right? But I want to get him out of the vehicle. And I want to get him out of the vehicle without tipping him off that he's being arrested or detained or whatever. So I'm gonna think, oh, it's just a taillight, right? I'm trying to get him out of the vehicle, right? What if? I haven't watched this video. It could be anything. But what if? What if, right? What if? So police officers can lie to you, and they often do lie to you. So we don't know. We don't know what the cop knows at this point. So because discussing laws, because Mark Adams is stupid, he's going to take everything the cop says as true. I, on the other hand, am going to assume the cop is lying to try to get the defendant in this case to do something or not do something based on lying, because that's what cops do all the time. They will lie to suspects all the times.
See your ID, please. I have one. Okay. You don't have one at all? I haven't violated anything or heard that First Amendment, so I'll need to show your ID. You actually stopped.
Now, this is a traffic stop. Why is the police officer asking for ID? An officer should ask.
Why traffic? Why would the officer ask for ID? Because he's driving a motor vehicle? Probably because the cops already run the license plate and knows about the arrest record of the owner of the vehicle, and the fact that the owner of the vehicle probably has a license suspended or whatever. Like, why would he ask? Why, when a cop pulls someone over, why would the cop ask for ID? Let's think. In every single fucking traffic stop ever, what's the first thing the cop asks for? Your ID. He might start off with, do you know I stopped you? But inevitably, the cop will ask you for your ID. Why? Because you're driving a motor vehicle. And as part of your agreement with the government to be able to drive a motor vehicle on state roads and county roads, you have given them, you agreed to provide your ID in exchange for driving on the road. And guess what? I'm not even going to look it up. I'm just going to tell you that you have to show your ID if you're stopped, if you're lawfully stopped in Oklahoma. You have to.
Ask a driver for a driver's license and pedestrians for ID, especially in Oklahoma. That is not a stop in ID state where the police can't demand a non-driver for ID. Why aren't you all?
Why? So the cop is asking for an ID, maybe because an ID would be something to verify this guy's name and address and date of birth, because the cop probably already suspects that the dude doesn't have a driver's license, because the cop probably already ran the plate and figured out this motherfucker has a suspended, revoked, or canceled driver's license. Jesus fucking Christ.
Always asking for a driver's license when you're stopping drivers. Could it be because the police are so well conditioned to try to get consensual access to IDs from non-drivers?
Or could it be because he's just saying, give me your ID, because an ID would be a driver's license? A driver's license is a valid form of ID? Maybe?
Anyway, if one was to be a pedant, Mr. Riles has his amendment number incorrect, but he is correct that he doesn't have to show ID. He is legally required to show his driver's license, though, which is not the same thing.
In California, you are not allowed to possess a California state ID and a driver's license. You have to pick one. Either you have a driver's license or you have an ID. Now, there are people out there who have both because they haven't surrendered their ID when they got a driver's license or whatever. But you're allowed to have one or the other. And whenever you go to the liquor store to buy, I remember being young, and whenever I would go to the liquor store to buy beer or whatever, they would ask me for my ID. I would present them with my driver's license. Why? Because I wasn't a piece of shit who didn't have a driver's license. I did have a driver's license, and so I would present my driver's license as my ID. Your driver's license probably says somewhere around on it, that your driver's license is valid ID.
Assuming that the police officer has pulled him over for minimally the suspicion of a traffic infraction, he should show his driver's license if it's demanded. Here, the police did not even request his driver's license. Note that
I don't think a court in the world is going to accept this stupid shit argument. The stupid semantic games win stupid semantic prizes. The cop doesn't have to use magic fucking words. He asked for the guy's ID. The guy should have a form of ID presented to the cop, a form of state-issued ID. Can I see your state-issued driver's license, please? He doesn't have to say that. He could be like, show me your ID.
officer pulls Mr. Riles over for the suspicion of or probable cause for a non-traffic crime, the officer cannot technically demand to see his driver's license, even if the driver's license would prove the crime. Although he wouldn't.
If he's operating a motor vehicle and the officer stops him, do I need to look this up? Do I need to look this up? Do I have one of these tabs open? I do. Awesome. A person shall not apply for or possess more than one state-issued or territory-issued real ID compliant driver's license or identification card pursuant. So you can only have an ID or a driver's license. There we go. Every licensee shall have his or her driver's license in his or her immediate possession at all times when operating a motor vehicle. Upon demand of a peace officer, the licensee shall produce and provide physical possession of the driver's license to the peace officer. That's on demand. On demand. On demand. Now, of course, the officer has to have probable or reasonable suspicion to pull you over, right? But on demand. If you're going through a DUI checkpoint, and the officer says, "Show me your license," guess what you have to do? Guess. You're never going to believe it. You're never going to believe it. Guess what you have to do? You have to show your driver's license. Why? Because you agreed to it. That's something that you agreed to when you got the driver's license. You shall. It's mandatory. On demand. Fucking hell. You're operating a motor vehicle. They say, "Show me your license." You got to show it. On demand. And you can only have one form of ID. Ha! Hold on a second. He has to show a driver's license. What were you talking about, bro? On demand. On demand. It's just on demand. No, he's operating a motor vehicle. On demand. On fucking demand. Magic words. Magic words. Mark Adams believes in magic words. Not in the garage. I don't know. Like you think if you, oh fuck. All right. Michelle says we have to start all the way over again. All the way over again. All the way back to the beginning, Michelle.
License, though, which is not the same thing. Assuming that the police officer has pulled him over for minimally the suspicion of a traffic infraction, he should show his driver's license if it's demanded. Here, the police did not even request his driver's license. Note that if the officer pulls Mr. Riles over for the suspicion of or probable cause for a non-traffic crime, the officer cannot technically demand to see his driver's license, even if the driver's license would prove the crime. Although he wouldn't
We've already discussed this on demand.
have to show his driver's license, Mr. Riles would be required to identify himself by providing his name and date of birth.
Nope. Operating motor vehicle. You have to show your driver's license on demand.
Then when I pulled in here, then he pulled me over. So I've been
Divided, so
recording
now
this
can you
whole
start
time.
another?
Yeah, go ahead and start another unit.
Okay, your third brake light is out. And perfect enough. My supervisor's pulling up.
All right, that's cool. Thank you.
So you have no ID on you. Are you refusing to identify yourself?
I don't talk to police.
Now, the police officer is asking Mr. Riles if he's refusing to identify himself. This is a valid traffic stop, then Mr. Riles would have to identify himself if the police officer demanded it. Here, the
No. It doesn't have to be a valid traffic stop. It's on demand. It's on demand. On demand.
police did not request him to identify himself. Mr. Riles answers that question great, though, not admitting or denying that he was refusing to identify himself. Now,
Magic words. I'm not going to answer your question on whether or not I'm refusing to identify myself. Well, you haven't identified yourself, and the cops demanded it, and the cop thinks that he's entitled to it, and well, we've already seen that you're going to fucking take a ride, and we've already seen that you're going to get charged with DUI and all that other shit. So I'm going to guess that all of Mark's legal opinions are worth about as much as some of my chicken shit.
It is possible here that Mr. Riles himself is confused here and thought that he didn't have to show his driver's license and wasn't just looking for legal loopholes to prevent from showing it. If he actually believed that he didn't have to show his driver's license here if demanded, he would have been wrong, although this is a common misconception. Mr. Riles mentions that the police didn't light him up until after he'd stopped in the parking lot. This is not an issue, though. The police have privilege to do a traffic stop in a parking lot or even a private citizen's driveway, including the citizen's own driveway, not in the garage, though.
And again, like this is where we had got to. There's no like, you know, ollie oxen free if you make it into your garage before the cop lights you up. I mean, if you get the door down before the cop lights you up, then yeah. But like if the cop, like if you turn the corner onto your street and you hit your garage door and you make a break for it and you get into your garage right before the cop lights you up, no, it doesn't work that way. I mean, or if you think it does, fine, show me the case law that says that like once you get a foot into your garage, then all of a sudden the cop loses the authority to make an arrest. Like if you're on foot, for example, and you run into your house, the cop can chase you in there if he has probable cause. So like, I don't know where he gets this stuff.
Also, the statute of limitations is generally 365 days for traffic infraction. The police could wait up to 364 days before they let you up and cited you. However,
well, I'm not going to bother to look up the statute of limitations on a traffic infraction. I don't know why they would bother to wait. Normally the cop has to see you do it.
where you probably would not be expected to have your driver's license on you if they waited until you had left the vehicle. They'd also have a harder time proving that you were the one driving the vehicle.
Mark is so fucking stupid.
Well, easy enough. Go and put your car park for me. It's in park. Okay, cool. Oh, it's good. All right, go and step out park for me.
I'm pausing it here so you can see that the third tail brake light is not out. Perhaps the plastic cover is broken and it's not showing red or amber. But it's hard to say because the police just stayed out. It looks lit up to me. At this point, it seems more likely that Mr. Riles was pulled into the parking lot. The police followed him in, saw that he was black, and decided to light him up.
Oh, it's racist now. It's racist. They saw that he was black, and so they decided to light him up. You know, it's pretty fucking weird how the guy that they just randomly decided was to light up. Turns out that he had he was under the influence of alcohol. He resisted an officer. He's driving without a license. Unlawful possession of a dangerous substance. Unlawful possession of drug paraphernalia. That's freaking weird, right? Just random. Just because he's black. Random. Fucking. Wow. Wow. Whew. Thank God. Thank God we. Oh, shit. You can't see any of this. God damn it.
That you were the one driving the vehicle.
Okay, well, easy enough. Go and put your car in park for me. It's in park. Okay, cool. Oh, it's good. All right, go and step out of the car for me.
I'm pausing it here so you can see that the third tail brake light is not out. Perhaps the plastic cover is broken and it's not showing red or amber. But it's hard to say because the police just say out. It looks lit up to me. At this point, it seems more likely that Mr. Riles was pulled into the parking lot. The police followed him in, saw that he was black, and decided to light him up under the pretext of an out third brake light. Also, the cop has just asked Mr. Riles.
Or the cop is lying about the taillight being out, which these dunce caps never seem to take into consideration. Cops can lie. So the cop could be lying. He could straight up be lying about the taillight being out because he's run the plate and figured out this guy didn't have a valid driver's license and had priors. And maybe the guy was weaving. I mean, look at where the guy stopped. Just do sober guys stop like that? Is that how sober guys stop?
Riles to go ahead and step out of the car for me. Mr. Riles appears to be driving a truck, not a car.
And this is the truck, not a car. Like, congratulations, Mark. You figured out that that's a truck, not a car. You figured out it was a driver's license, not an ID. Boy, howdy, Mark. I hope this guy retains you to defend him in Oklahoma. Jesus Christ.
No. Okay, so this is how this is going to go, okay? I have a legal right to remove you from the vehicle.
Hold on. Hold up. Wait a minute. I still got my dick up in it. Hold on. See, Mark could have stopped it there. You know, Mark could have stopped it there. Because that doesn't look like a third taillight up there. I mean, maybe he has his reverse lights on or something like that. Or what's that light they turn on? They could turn on that backlight to shine into the bed. That's Mark could have stopped it here. He didn't.
I have a legal right to remove you from the vehicle. It's case law from the Supreme Court.
No, it's not.
It 100% is. You've been pulled over for a traffic violation. Can you please let me finish?
So the police says, I have the legal right to remove you from the vehicle, and it's case law from the Supreme Court. He's probably talking about Pennsylvania versus Mimms, but is he correct about having the right to remove Mr. Riles?
Yes, he is. 100%. Unequivocally, yes, he is. And if you're going to pull some shit about officer safety, let me remind you that our goodly driver here has priors for carrying concealed, unlawfully carrying concealed. What was the other one I pulled up? There's a bunch of misdemeanors and felonies. Oh, that's a junior. I think that is. Oh no, that's him. That's him. It's the right date of birth. Home repair fraud. That's pretty cool, right? I'm not going to show you all these. I don't want to violate this guy's privacy too much. There's a DUI for alcohol, marijuana, transportation of an unlawful transportation of a non-intoxicating beverage. I don't even know what the fuck that is. Illegally transporting a non-toxic beverage. That was back in 2003. Traffic. Oh, let's see what you did. What were you? No insurance. Another one. This one is driving under a revoked license. That's nice. That was also in 2004. The 2005 one, this was the possession of marijuana and a concealed weapon. And let's see what this one is. This one is bad checks, writing false checks. Let's see what this one is. Violation of a protective order. That's not good. Somebody got a protective order against him and he violated it. Let's see where we're at. That was in 2007. Let's see, 28. Oh, no, it was 2018 that was the violation of the protective order. And let's see, 2019, there's the felony that I think we've gone over this one. That was the assault and battery with a dangerous weapon. Assault and battery with a dangerous weapon. How was that? How was that resolved? How was that resolved? It's ongoing. It's ongoing. It's ongoing. It's ongoing. Let's see something here. So this, share this tab instead. So this is the Real Body Cams channel. This is the one that Audit the Audit stole it from, and Discussing Laws stole it from. So they say this happened in September 17th, 2022. And there was a hearing that was continued to 11/15/2023. This is in the felony assault with a deadly weapon case. Assault with a dangerous weapon. So that's ongoing. That's ongoing. Hold on, I'll share this tab instead just to get off of that. And the officers would have been aware of all this. What is this one? Is that a different felony? That's the home repair fraud felon. That was in 2018 as well. But no, that was 2020. That was filed in 2020. Then we have what's a CPC? Criminal probable cause initial filing. I don't know what that is. They don't. So whatever that one is, I can't see it. Then another misdemeanor. This is the one. All right, this misdemeanor is the one that the videos of. And then subsequently, there was a speeding ticket. And last, but certainly not the least, a driving under suspended license. And that was all in one county. That was in Oklahoma County. Let's see. In Cherokee County, there is another misdemeanor. This misdemeanor is for possession of marijuana. Guy really likes his marijuanas. That was in Cherokee County. Any others? All right, we got a couple in Rogers County. We've got speeding. That was in 2017. And very last one is a driving on a suspended license, third or subsequent. All right. All right. Now that we've gone through his criminal record, let's go back to this dipshit talking about it without having a fucking goddamn idea about what's going on. without a single idea. Mark's discussing this without a single idea of what's going on.
Perhaps he means that he can order Mr. Riles out of the vehicle if he has a legitimate need that outweighs Mr. Riles' right to personal security, free from arbitrary interference by law officers.
Nope. Maryland versus Wilson. As a matter of course, cop can order him out.
I've been recording
Okay,
the whole time.
you have a third break. Hit your brakes. Hit your brakes. So,
So he seems to be doing another investigation. Good job. It's hard to know the results because the video is cut here. I'm assuming it's because it makes the police look bad, maybe.
are you refusing to exit the vehicle?
Yeah.
Okay. If you don't exit the vehicle, I'm going to place you under.
Well, hold on a second. Let's go to the original video. And this is the original video.
Recording this
Okay.
whole time.
You have a third break. Hit your brakes. Hit your brakes. So are you refusing to exit the vehicle?
Yeah.
There was
Okay.
a cut in there. So that's from Real Body Cam's channel. So, all right, to continue. Well, the officer can lie. Let's see again what he was charged with. And what he was charged with was resisting an officer in violation of 21 OS 268. Resisting an officer. He was charged with it. So apparently somewhere in there, you shut the hell up. You shut the hell up. Somewhere in there, he apparently resists. But again, officers can lie.
Turns traffic stop into an arrest for no reason. I think the narrator is probably referring to the driver to give him a hard time.
Traffic stop into arrest for no reason other than the driving drunk, the driving on a suspended license, the no reasons.
Especially given how the narrator rates the interactions accordingly at the end. However, I think the title could more likely be describing the police officer because he's the one that thinks he's a legal expert, and spoiler alert, turns the stop into an arrest for no reason. So let's discuss the
Turns a stop into an arrest for no reason.
law here. The police officer does have the authority to order Mr. Riles out of the vehicle, but it's the authority granted to him by state statute and not by Pennsylvania versus Mimms.
I don't know about that. I don't know. I haven't seen the statute, and I don't care to look it up. But why did he bring up this whole fucking Pennsylvania versus Mimms shit? If why did he have to bring this up if there's a state statute that says you can do it? Like, why?
The same statute that allows the cop to investigate and arrest. Technically, this is an equipment violation, not a traffic violation, but same thing. All the cops.
Well, now again, the whole taillight thing might just be a prefix. Not prefix. I don't know. The word just escaped me. But it might be the cop just pretext. It might just be a pretext. We don't know.
All the cop needs is for the traffic stop to have been the result of an actual traffic infraction or crime, and the officer needs to weigh public interest against the rights of Mr. Riles. The cop probably doesn't even have to explain his analysis. However, how is the cop going to get Mr. Riles out of the vehicle without some convincing and explaining his analysis?
Without some convincing, I don't know, through the use of force. That would be a way to get someone out. We've all seen the broken windows and tasers and everything like that. If the cop can't get the guy out by saying "get the fuck out," then the next step is an escalation. The cop can use reasonable force to effectuate an arrest, and this guy's getting arrested
Through reasonable force, right? If the search and seizure analysis results in the cop being able to order a driver out of a car, he can only use a reasonable amount of force to get the driver to comply under Graham versus Connor. The Graham factors are: 1, the severity of the crime at issue. Here, the severity of driving with an out third brake light would not authorize any use of force. 2,
no, so resisting arrest. The cops are going to arrest him. There's two statutes that could come into play. There's the obstruction or delay, which is a lower level one, and then the next step up is resisting.
Whether the suspect poses an immediate threat to the safety of the officers or others. Here, the dude is just
the guy has a criminal record for assault with a dangerous weapon, for carrying concealed, for violating protective orders. I don't know. He doesn't sound like so much of a nice guy, right?
sitting in his car smoking a cigarette. The police have not acted in any way to show that they fear for their safety. And 3, whether the subject is actively resisting arrest or attempting to evade arrest by flight.
Ooh, actively is this resisting arrest? What?
Here, dude is just sitting there. His vehicle seems to be boxed in, and the vehicle is in park. Sorry, but using force.
He's not getting out of the vehicle, and so they get to use force to go in after him.
To get Mr. Riles out of the vehicle is simply not going to be permissible in this case.
I'm giving you a legal order. I'm giving you a legal order.
Well, Mark's prediction certainly hasn't seemed to come to fruition in the well over a year that this case has been ongoing. So, I don't think Mark was right.
What am I resisting arrest from?
Okay. I'm giving you a legal order to exit this vehicle. I'm giving you a legal order to exit this vehicle.
Do you think the police officer repeating "I'm giving you a legal order" in a louder and louder voice is helping? The officer is making legal conclusions. He's not explaining anything. Is it working?
You know, I don't know. I don't know if you really want to backseat drive a cop. Like I've never been a cop. I don't know what to do to get someone who's not wanting to get out of a vehicle out. I don't know their policy. I haven't been through police academy training. I don't fucking know. And you know who else doesn't know? Mark. Mark has no fucking idea. Mark's just fucking pissing in the wind and hoping he doesn't get wet at this point.
Keen to de-escalate the situation.
The officer informs Mr.
All right, so here's where the narrator correctly says that Mr. Riles is probably not guilty of resisting, but rather obstruction. I'm skipping that part. If the police officer actually was able to order Mr. Riles out of the vehicle, then yes, Mr. Riles was obstructing. Excuse me. There are a couple issues, though. Was the third brake light actually out? And what was the officer's need to have?
Well, we haven't seen the whole video yet, so I don't know, right? Did we get to the part where there was actually resisting arrest? Did we get to that part? I don't know. Is just this guy refusing to get out for a few minutes and then he gets out? I don't fucking know. None of this. I mean, we're jumping into State versus Nelson. Holding defendant's behavior and walking away from a traffic stop for failing to signal a left-hand turn was an intervening circumstance which purged any taint originating from the illegal stop. I read this case today. And the holding in this case, what the defendant in this case was trying to do, and I did not actually watch the video to get to this point. This came up when I was Googling around. What the defendant was saying was that the traffic stop, that it was a bad traffic stop. I remember that it was a bad traffic stop, and he was not convicted of the traffic stop, and he was trying to make an argument that, like fruit of the poisonous tree, that the subsequent resisting arrest was tainted by the bad traffic stop, and the court said no. It's not tainted by it. You decided to do this. You could have sat there. You didn't have to resist arrest. You decided to do it. But let's look it up. State versus Nelson. Let's look it up. Inspect what you expect. Let's see if I'm right. I want case law. Select courts. And we go to Oklahoma. State v. Nelson. All right, share this up instead. All right. So the initial stop was illegal. They said that the obstructive behavior following the stop, which ultimately led to his obstruction for arrest for obstruction and resisting arrest. They say that he abused his discretion when he suppressed the evidence relating to Applebee's or the Pelly's obstruction resisting as fruit of the illegal stop. The judge Huddle ruled, but you can resist an illegal detention or arrest. I've ruled the detention and arrest are illegal, so there you go. The traffic stop is a seizure. In the present case, the lapse of time between the initial stop and the obstructive conduct was minimal. However, despite the brief lapse of time, Officer Turnbro did not discover the challenged evidence. Rather, Appelli's behavior actually created the now challenged evidence. This distinction leads us to the second factor, presence of an intervening circumstance, yada, yada. Blah, blah, blah. Termination shows proposition third error. Foregoing conclusions, cognizant Applebee's alleged obstructive behavior not on form legal basis of the obstruction charge, but arguably could be reviewed as general rule, blah, 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 as noted, blah, blah, blah. Majority states, blah, blah, blah. We likewise decline to extend the right to resist to an illegal traffic stop. So they declined to extend the right to resist to an illegal traffic stop. You have no right to resist an illegal traffic stop. And so, anyway, all right. Well, let's see what Dumb and Dumber has to say about it. Obstruction. It's obstruction. I don't know why Dumb and Dumber are talking about obstruction. There was
actually was able to order Mr. Riles out of the vehicle, then yes, Mr. Riles was obstructing. Excuse me. There are a couple issues though. Was the third brake light actually out, and what was the officer's need to have Mr. Riles exit the vehicle?
Illegal traffic stop, and that consequently an individual could be convicted of obstruction for refusing to comply with officer commands during a traffic stop that was later held to be illegal. In reaching this conclusion, the court argued that, now I'm quoting, the typical motorist simply is not equipped to make a determination of whether there is a legal basis for a traffic stop, and that the issue of whether an officer has probable cause to make the traffic stop, now quoting again, should be resolved in a courtroom, not in the streets. Accordingly, even if a court determined that the underlying traffic stop was unlawful, it is still likely that it would conclude that Mr. Riles violated the obstruction statute by refusing to.
He wasn't charged with obstruction. He was charged with resisting. I don't know why we're talking about obstruction.
Exit the vehicle.
All right, so this part I have to disagree with. After reading that case, it doesn't seem factually relevant. Mr. Riles was not resisting the detainment of the traffic stop, such as fleeing, like in State versus Nelson. He was maintaining the status quo and had not resisted being detained. The police were to provide a valid explanation on why they needed him out of the vehicle to perform their duties, and then
they don't need an explanation. They can order him out as a matter of course.
Mr. Riley refused to comply. Then Mr. Riley would have knowingly obstructed their duties, unlike resistance.
Yeah. Fuck. Let's see here. Let's see if we can find that particular. All right. That's resisting with that one. All right. Share this out instead. This is obstructing. You have to willfully delay or obstruct a peace officer known by the defendant to be a peace officer in the discharge of any duty of his or her office. Did the driver delay? Yes. Did the driver obstruct? Yes. Ergo, obstructing. They didn't charge him with obstructing. Why did they charge him with obstructing? Probably because they felt like they had enough to do resisting. And I'm just guessing. I don't know. I'm just guessing that obstructing is probably a lesser included in resisting. I'm guessing. I don't know. Because he was charged with resisting, i.e., the use of force or violence.
Resisting obstruction doesn't require an active role. That is not, unfortunately, that's not what happened, though.
Doesn't require an active role? I don't know. I doubt he looked up case law to figure that out.
giving you
I
legal
was in
order
the
to
parking lot. When
It doesn't matter. You committed a traffic violation on the road.
Any traffic violation.
You have a third brake light out. That is a traffic violation, an equipment violation. You can step out of the vehicle right now, or you will go.
I do not have.
Are we gonna unit over
That's
here?
my First Amendment right.
Okay.
So
You obviously don't understand how the First
I stopped in the parking lot. Then you turned on your lights.
Good.
This officer is failing horribly at de-escalating and has made no progress in actually requesting a driver's license, proof of insurance, and registration, nor has he done anything.
I don't know if Mark has a real good understanding of what escalating means. Escalating typically in the police interaction means escalating up the chain of violence. Verbal commands. If that doesn't work, then you try to like use some force to pull them out. If that doesn't work, then you use a taser. If that doesn't work, then who fucking knows. But is he a hair lip? No, he doesn't have a hair lip.
To move forward the citation of Mr. Riles or his alleged equipment violation. The supervisor's coming in now. Let's see if he makes things better.
So you just turned on your lights when I was in the parking lot.
Okay.
So I have a First
It's a
Amendment right.
traffic stop.
For what? I was already in the
An
parking lot.
infraction
Then
based
he
on
turned
the
his
roadway,
lights.
sir.
Say again, sir?
An infraction that happened on the roadway.
No, that's not what happened. I pulled in the parking lot. Then he turned on his lights.
Yeah,
Because
that can be
I'm
a
here establishment. You guys saw me pull over here. So because I missed my turn, then you turned on your lights after I pulled into the parking lot because I missed my turn. Now all of a sudden it's all this whole thing. So you're trying to violate my First Amendment.
That's not what's
Now, I
happening.
report it the whole time.
First Amendment's a freedom of speech, sir.
So First Amendment, Fourth Amendment, et cetera, et cetera.
Okay.
I like how he recovers from that. He was referencing the wrong amendment, but he's like, rights are rights. You knew what I meant. The supervisor at least speaks calmly, but he also sucks at explaining their authority to cite Mr. Riles. Additionally, the supervisor does nothing to move forward with that citation.
Well, argue with the cops on the side of the road. Discussing law starts off by saying it's a no-win proposition, and now here we are with him saying, "Oh, he didn't cite the right stuff." Well, like these cops, they don't know Pennsylvania versus Mimms. They probably couldn't cite the name of the case. They probably couldn't really delve much into the holding, but they know that it gives them the right to order you the fuck out of the car. They know they have the right to order you out of the car. Goddamn mosquitoes. They know that they have the right to order your passenger out of the car. They know they have the power, if you don't like me to use the word right. They know they have the power to do that. They know the Supreme Court said that, yes, they can do that. They could do it. And they're not wrong. They can't name the case law. It's pointless arguing the case. It's pointless trying to argue nuance. They fucking know that they can order you out of the vehicle.
So I do not have.
So you don't think your third brake light's out?
I don't think it's out.
If you guys are going to be pushing like this,
No,
I would recommend that I ask for a supervisor.
This is a supervisor. Mayor, he's a lieutenant.
All right. So if what I'm saying is resonating with y'all, I'm going to ask you guys to call the FBI.
No.
Okay.
Yes, straight up. Their number is 297. It's
listen.
not hard.
This guy's asking to call the FBI. That's a pretty good idea. Interesting. I mean, is somebody who's saying call the FBI on a traffic stop? Is that maybe that's a good indication they're drunk?
He stopped you for a traffic violation. Okay.
That's what you're saying.
That's what
No,
I'm
I
saying.
pulled in here, then you turned on his lights.
That's fine. That's a traffic violation.
No, I was
It's a traffic.
here.
Listen,
Yes, sir,
listen, I'm trying to explain
and
to you,
I
sir.
stopped, tried to
Sure.
reverse, and then you turned on the lights.
Okay.
Look at how my vehicle's positioned versus yours.
Okay, listen, you're not listening whatsoever. You just keep wanting to talk over everybody. Okay. He had a traffic stop conducted on you for a traffic violation that happened on the roadway. That's perfectly legal, perfectly fine. He's asking you to step from the vehicle.
The cat messes up here, I think, and says that the officer's asking him to step from the vehicle. Makes it sound like an optional request.
I had pulled into the
Cops do that a lot. They will make things that are demands sound like requests, but it's not. I mean, they're just making it sound like a request. I'm asking you to step out of the vehicle, and what they're really doing is they're telling you to step out of the vehicle. You don't really have an option because they don't go away, and they keep saying, "I'm asking you to step out of the vehicle." They prefer that. They prefer it if they phrase it, "I'm asking you to step out of the vehicle," because then it sounds like you're doing it on your own free will, right? It sounds like if they go to court, they could testify, "I asked him to step out of the vehicle and he stepped out." It gives them an extra layer of protection from any potential Fourth Amendment challenge. But at the end of the day, they have the right to demand that you step out of the vehicle.
parking lot, then you turned on the lights. Period.
Okay, we've explained it now.
I don't think it's
That's
okay.
not working tonight.
No, we've explained it a few different times.
No.
Okay, we
That's
just-
law. You guys are trying to violate my rights.
Mr. Riles argued
Here, the narrative goes into the statute related to a third brake light and case law related to initiating traffic stops in a parking lot. We're going to skip over that part.
And like why they're going on about the third taillight. This is fucking ridiculous. Like, look at what he was arrested for. Look what he was cited with.
brake light.
Good, step out.
No.
Okay, we are under arrest. Okay.
So they finally told him he's under arrest. Now they should explain to him that they need him to exit the vehicle so that they can take him into custody and warn him that if he uses force to prevent his arrest, that he'll be in trouble for resisting. Although one can lawfully resist an illegal arrest, one probably shouldn't, especially if that person is black. Now, if he's been
Wow, especially if that person is black. Well, here's the thing. It's not an unlawful arrest. And he shouldn't resist because it's not an unlawful arrest.
unable to get the cops to look at his exculpatory evidence, he should probably just cooperate. In addition, when a police officer takes someone into custody, especially after you've frustrated them, they're going to use an intermediate amount of force to effect that arrest. You are highly likely to have a knee in your back, and if there's more than one officer, more than one knee, then it's unfortunately legal to always use some force, even if it's not necessary. So if you're not a healthy person and can't handle that force, make sure and start sharing your medical needs, such as injured shoulders or back. If you have the opportunity, before they say you're going to be arrested, you should lean up against the hood of the car with your hands behind your back. They should then handcuff you there, and you won't get a knee in your back. You know when people can't breathe while being restrained, it's from being on the ground, usually with some weight on them. There's been a lot of new
Mark's a fucking expert on this, right? Jesus. Like, he's talking a lot of shit about the shit he doesn't know.
legislature to protect us from police force. Some states now have laws where if you say you can't breathe, the police must immediately get you medical care. The case law and new chokehold laws say you're most protected from excessive force once those handcuffs get on you too. So don't let them beat you up while they take their time putting the handcuffs on. Actively work to get those cuffs on you as soon as possible. If you get banged up, make sure and let them know because they are required to get you medical aid. Let's see how this arrest goes.
I'm not under arrest. I'm not getting up. You guys are violating.
When Mr. Riles
The cops do a better job than most here. They ordered him out maybe 8 times before they physically remove him. I don't see how any of the de-escalation mentioned in their policy though. And then, so here.
That's a very good point, Scissors. You seem like a very trustworthy clown giving that kind of advice.
The narrator does a copy job of analyzing the excessive force, but he still gets to the right conclusion.
constitute excessive force.
Are you going to stand up and watch the car?
Yeah,
Well, that would have been helpful like 5 minutes ago, sir.
I've been pretty reasonable the whole time.
No.
I've been pretty reasonable the whole time saying no. Well, I guess the jury will get to figure out whether or not you've been reasonable.
Here, hold on, my shoulder's caught in your chair. Yeah, sure there. Well, if you go there, I got you. There we go. I'll stand on your chair.
So we saw them carry Mr. Riles. In some states, it's illegal to passively resist arrest like that when you go limp and make them carry you. That's not legal in Oklahoma. They then lay him in the car in the stomach, which is a violation of a lot of chokehold laws now. I don't know if there's one in Oklahoma yet against that. They also intentionally tear a shirt to drag him in the car. It appears to be as punishment for having to load him in the car that way. So the last part is just going over their gradings of everyone. So they gave the police officers an A-, which I think they did earn, maybe an F-. And then...
Well, audit the audit's fucking retarded. And I don't know why anyone would give any shits about what audit the audit says. He's not a lawyer. He has no legal training. He has no understanding of the law better than Chili does. He's a fucking retard.
Then they gave Mr. Riles an F. I think he probably should get a C. The misconceptions that he had are pretty common, so let's do C for common.
He should get a C? He should get a C? Why should he get a C? I don't know. A C for driving under the influence of alcohol, for resisting an officer, for driving with a canceled, suspended, or revoked license, for unlawful possession of a controlled dangerous substance, for unlawful possession of drug paraphernalia. I don't know. Is that a C? I think it's an F. An F for felony? No, these are all misdemeanors. This is a misdemeanor DUI, misdemeanor resisting an officer, misdemeanor driving with a canceled license, misdemeanor possession. So maybe we'll give him an M. Maybe we'll give him an M.
AKA average. That's all I got for you. Thanks for tuning in. Bye.
So that was a whole lot of stupid. It had nothing really to do with Pennsylvania versus Mimms. Anyway, that's all I got for you today. Thanks for watching. Let's see. Is
Yeah, one of the great sites.
Yeah, and I got to go there a couple times. That's where he housed, like, all the, that's where some of the PhDs are working. So
We had one guy over there, and he, like, I never saw him. But he wasn't really it was weird because our NCR office or National Capital Region was, again, like in
everybody go head over to Wally's channel.
but
Head over to Wally's channel.
not everybody
In the
was working on
description.
the same
Yeah.
thing.
Head over to Wally's channel. Links in the description. Thanks for watching. Links in the description. Wally's channel. Go, Wally. Wally Raid. Go, go, go. Thanks for watching. Have a great day.